Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing the result in the case of Jordan Peterson and the College of Psychologists of Ontario. The college is the regulator for clinical psychologists, and they ordered Dr. Peterson to complete an education program to address what they called issues regarding professionalism in public statements. This all arose out of some statements Dr. Peterson had made on social media about a variety of issues, from climate change to gender ideology to partisan politics. Dr. Peterson has challenged that order, calling it re-education, saying that the regulator does not have authority to police his speech unrelated to the practice of psychology. He also pointed out that the college investigated these statements because of complaints made by members of the public, not because there had been any complaints made by his patients or even by the people he was tweeting about. Well, the result of the Dr. Peterson legal challenge is in. The order for re-education stands. Here today to discuss this result are two experts, Joanna Baron of the Canadian Constitution Foundation, the charity that I work for, and George Avraam, who represented the CCF in the intervention in the Dr. Peterson matter. Thank you both so much for joining me today. Joanna, at the top, obviously this is a very disappointing result for us, I'm sure for Dr. Peterson as well. Do you know if there are any plans from Dr. Peterson to seek leave to appeal?
So understanding is that, yes, he has publicly announced that he intends to seek leave to appeal. And I'd also add that the CCF, we will also seek leave to intervene at the Ontario Court of Appeal level.
If he's granted leave, right? Now, George, let's talk about the decision itself. The court dismissed the judicial review, and they found that the order for retraining for Dr. Peterson was reasonable. At a very high level, why did they find this?
Yeah, no, thanks, Christine, and thanks for having me. I mean, I think the fundamental issue here is what we lawyers and administrative law junkies deal with, which is the standard of review. And the standard of review is, was this decision reasonable? Not, the question isn't whether it's correct or not. It's whether it's reasonable. And what they found, based on, candidly, a line of case law that most of the administrative and constitutional bar are still scratching their heads over, called Dore and Loyola, about how you balance charter rights against statute regulators' objectives. They found it reasonable, right? So what they said is the public comments he made, even though they weren't complainants in the normal course, his patients, rose to the level that it could, and let me underscore, could cause harm to the public, and therefore the inquiries, complaints, and reports committee issued what they call a remedial order, not a disciplinary order, ordering this training or retraining. And that was really the crux of it. The other key part is that Dr. Peterson, his defense, when they were dealing with the judicial review, really said, look, this is nothing to do with my practice. This has got nothing to do with my clinical psychologist practice. I think the college took a slightly different view because he said, as a public figure, and this is where I think there's a distinction, he is helping people out there with his commentary, and in a broad sense, he's acting as a clinical psychologist. So the court took that statement and said, Dr. Peterson, you can't have it both ways.
Yeah, that really stood out to me. There's a lot to dig into there. A few things I'm going to follow up on later in the program. The notion of whether or not this was actually discipline, this idea of Dr. Peterson having a broad practice in the public, and the other thing is what the notion that there can be this administrative action in response to hypothetical and unproven harm. We're going to get into some of those issues later, but Joanna, in the remaining minute we have here in this segment, what's your high-level reaction to the decision?
Yeah, so echoing what George said, there was a tremendous amount of deference shown. And I think part of the problem is this line of administrative case law that George referenced, Dore. But I also think that it was a convenient amount of deference, and there was really not even a facial attempt, because of course there is in Dore still an indication that you do have to recognize where a charter right is engaged, which nobody disputed, that the right to freedom, that Dr. Peterson's right to freedom of expression was engaged. There needs to be some recognition of that by the regulator. And here there was a one-line throwaway. I also found it interesting that one of the facts that I found interesting in this case was that there was a precedent, and that was not dealt with in a very convincing way.
Oh, a really important one. Let's discuss this after the break. Welcome back to Canadian Justice, where we're discussing the decision in the Jordan Peterson freedom of expression case. Now, Joanna, in the last segment, we were discussing something interesting that the court made note of, which was that there was this precedent for non-discipline discipline against Dr. Peterson for some public statements he had made. What do you want to say about that?
So in 2020, there was a very similar complaint lodged by members of the public on the basis of very similar tweets and public comments by Dr. Peterson. And in that discipline committee decision, the committee made notice of Dr. Peterson's charter rights to free expression and just indicated to Dr. Peterson that he should deliver his comments in a respectful manner. So there was no disciplinary action taken. Now, on a very similar set of facts, this committee came to a very different outcome. In the divisional court's decision, they almost make of it that was like a warning. But even the college didn't make that point. To me, what it indicates is how kind of capricious and unpredictable these decisions of administrative bodies that have real impacts on charter rights can be.
George, one of the things that we've been talking about is whether or not this order for retraining was actually discipline. And the college and the court both found, the college argued it was not discipline. The court seemed to have found that it was not discipline, but Dr. Peterson argued that it was. So how would you characterize this order for retraining? What's your perspective?
I mean, I think the issue is it is likely a remedial order, but with a big but, because there's an order. And the order says he has to engage in the training. And the order says it's silent, actually, on what happens if he doesn't do the training or if he doesn't complete it successfully based on what the coach determines to be successful. And that's where it can turn into discipline. And that's why it was actually reviewable, because usually on these remedial orders, and the court makes reference of it, it's usually not subject to judicial review because you go to the discipline part of the regulation or sort of the statutory body. So it is remedial, but with a big but, right? I mean, and that was a lot of was made out of that in argument, less so in the decision.
Joanna, anything you want to add to that? The thing that stands out to me about this order for retraining is that it's for an indefinite period of time and at Dr. Peterson's own expense. So if that's not discipline, I'm not quite sure what is. Any reaction from you, Joanna, about that?
Now, as George mentioned, this is one of the most interesting back and forths between counsel and the judge at the hearing. And counsel for the college, which also denied that this was an order and it was disciplinary in nature, faced pushback from the bench that essentially, but ultimately, this is backed by an order and there will be consequences for noncompliance. So you can't really explain that away by just saying it's a coaching program. It's a mandatory coaching program at Dr. Peterson's expense for an indefinite period of time. And of course, Dr. Peterson, his imagination being what it is, made a lot of the fact that it's a forced re-education.
Now, George, what precedent do you think that this case sets for other people in regulated professions, doctors, lawyers, etc.? What should our takeaway be about our freedom of expression and its relationship with our regulator?
I mean, the regrettable part about this is we've got a unique set of facts because, sure, Dr. Peterson is a clinical psychologist, but he's a public intellectual who speaks on a whole range of issues. The line for him, candidly, has just been eviscerated between what his, public persona is and what his clinical psychology is, and it's not fair to him, quite frankly. He's not seeing patients. He's not talking one-on-one. He's not in his office dealing, consulting. He's not referring to anybody else. He's a public commentator, and yes, he's referring to himself as a clinical psychologist. But is he acting as a clinical psychologist in this circumstance? And I think that's the problem. I think, the CCF intervened in a case called Strom out of the Saskatchewan Court of Appeal. And the court there actually went to great lengths to distinguish the person there from the nurse that she was, and her statements being personal, not as part of her profession. And I think there was a lack of nuance both by the inquiry committee here as well as by the court.
Yes, it was interesting to me that the court, although they had been given copies of Strom was referenced throughout the oral arguments. It was never mentioned in the decision, which to me it's a highly relevant case. Joanna, in 20 seconds, any reaction to that?
Well, I hope that we talk about Strom some of the facts. It's distinguishable in a way that makes this case look milder. In some cases, arguably Strom was making those comments on social media, but to a private audience. But I think there's a lot of interesting interactions between that decision and this decision.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we are discussing the decision in the Jordan Peterson freedom of expression case against the College of Psychologists. Now, Joanna, one thing that stood out to me in this case, which we've referenced a little bit in an earlier segment, was just how little weight the College of Psychologists gave to the right to freedom of expression. In ordering the retraining, the college, they're supposed to weigh Dr. Peterson's charter rights and their statutory obligations to regulate the profession. But they basically had this one throwaway line essentially saying Dr. Peterson has a right to freedom of expression, and that was about it. That was the analysis, a mere glance towards the charter. How on earth could this be sufficient consideration of his charter right? And how could that bare minimum constitute reasonableness in this decision?
Yeah, I think I think the answer is this deference issue that we've touched on, Dore, that really this court said, we're going to be very deferential and we're going to assume if there's any indication on the record of the decision that charter rights were considered, that they were considered. Now, normally courts don't really accept that. That's quite facial. And the Canadian Constitution Foundation, in our intervener submissions, said that where charter rights are engaged, the regulator has a heightened duty to actually grapple with the impact of the restriction on the charter rights. But I think essentially this court was just happy to be deferential and take the regulator, the disciplinary committee's decision at their word. For me, that's not good enough.
George, on a sort of related note, one thing that was strange to me about this case is if the government itself were to be the one to impose this remedial penalty, non-discipline action, if they had done it itself, just, this mere glancing at the charter, this one throwaway line about freedom of expression, that would not have been enough. But because the regulator is empowered by statute, they get a different, lower standard of review. So they can get away with limiting rights more than the government itself actually could. So how does that make sense?
It doesn't. Short answer, if it was the government who did it, the standard would have to be correctness. How do you apply the charter as against his individual rights? Here you've got the Vavilov-Dore deference standard, which was, bizarre to all of us looking at it, or many of us who practice in this area when it was introduced. There's too much deference given when you're dealing with the charter issue. And going back to the analysis of the review committee here, there wasn't one to Joanna's point. And the court, I don't know how they did their analysis, because on the one hand, they talk about what Vavilov said, which is the Supreme Court of Canada decision about how to deal with reasons and reasonableness, and how do you figure out if the decision's reasonable. And they cite the terms justification, intelligibility, and transparency, which is what comes out of Vavilov, and you see none of that in terms of the charter analysis on Dore, and none of that. And Dr. Peterson's counsel at Divisional Court hammered that point home. I thought did a very effective job, and the court just didn't deal with it.
Now, we haven't got a huge amount of time left, but I'm going to pose this question because it's interesting to me coming from the court's analysis. They said that it wasn't necessary to engage with Dr. Peterson's comments and whether or not they were supported by facts or if they were his honest opinion, because they said that the concern came out of the language that he used, not the validity of his opinions. So to me, that reads sort of as, it's not what you said, it's how you said it. And look, I have literally had that fight with my husband, but I don't think that it's the role of the court to be policing tone. But that seems to be what they're doing here. Joanna, in about a minute, what's your reaction to that?
Yeah, the guarantee of freedom of expression is content neutral, right? So, first of all, it doesn't matter if you're expressing a protected ground of expression. It doesn't matter if it's offensive, if you don't like it. And it certainly doesn't matter if you do it in an offensive tone, which, again, you have this problem with a court several steps removed going in, dissecting tweets that were probably composed extemporaneously. Doing tone policing, as you say. And when you add the fact that this is off duty conduct that no reasonable person would think had any close nexus with the practice of psychology, you have a very loose and very distressing standard.
Now, when we come back from the break, I want to talk about something else, which is the notion that this mean tone could lead to harm to the profession and to the public without any actual requirement to prove that harm. We've got to go to break, but we'll discuss that when we come back. Welcome back to Canadian Justice, where we're discussing the decision in the Jordan Peterson freedom of expression case. Now, George, in this decision, the court noted that the College of Psychologists relied on concerns they had over potential harms that could arise from Dr. Peterson's language and tone. And the potential harms they identified included undermining public trust in the profession of psychology and trust in the college's ability to regulate the profession in the public interest. But this is merely an assertion of a hypothetical harm. No one Dr. Peterson made comments about, including a former patient, none of them actually complained to the college. There's no evidence of any actual harm. It's just that Dr. Peterson says things that they think are mean, and he says it in a mean way. So, George, why is this notion of hypothetical potential harm enough to outweigh Dr. Peterson's right to freedom of expression that's guaranteed in our Constitution?
No, it's a tough issue to grapple with, but I agree with your overall point, Christine, which is, look, he's subject to the code of ethics of the college. I think there's no dispute. The court makes a point of that. And within that code of ethics, there's something called respect for the dignity of persons and peoples. And that's what the hook was for them to sort of say his comments could result in harm, or there's potential harm. And you go full circle on this. If this is actual discipline, if the court accepts this as discipline, I think it's a harder case to make that potential harm is a reasonable decision. But because they positioned this as a remedial order, that it's easier to justify, I think this is the analysis of a potential harm, particularly when you take into account the reasonableness standard of review. So it's a bit convoluted. It certainly backseats the 2B, the charter right, undoubtedly, particularly when you're looking at the analysis done by the court, or the lack of analysis done by the court and the ISRC on the freedom of expression.
Joanna, on an unrelated note, one of the things that stood out in this decision to me was the notion about whether or not this was actually off-duty conduct. And the court said that Dr. Peterson doesn't seem to believe it was off-duty conduct. They found that him representing himself as a clinical psychologist is important to him. It lends him credibility because he has a position of trust, confidence, and responsibility in society. And the court wrote that he can't have it both ways. He can't speak as a member of a regulated profession without taking responsibility for the risk of harm, not actual harm, but risk of harm that flows from him speaking in that capacity. So what's your view on that position and finding by the court?
Well, you have to be very careful, right? Many of us have different identities where we're connected to regulated professions. All of us, for example, are lawyers. Does that mean that everything that we say publicly, including political criticism, personal commentary, that we have to do it while, while connecting ourselves to our profession. I think that this is a very dangerous, slippery slope, given how there's a huge chunk of society that counts themselves as members of regulated professions. And just because you put that on your Twitter bio doesn't mean that you're indicating that your tweets indicate psychological advice. And I think it was a very reckless comment by the court.
Yeah, I mean, just because it says your profession in your bio, does that mean every tweet and retweet are now under the purview of the regulator? George, about a minute, what's your response to that comment by the court?
Yeah, I mean, look, they took a statement Dr. Peterson made, which had a couple of points in it. One, he says, I have practiced since 2016. It's made it impossible to practice. I'm effectively a public intellectual. And he says, given that I am still licensed and still practicing in that more diffuse and broad manner, and those are his words, and that's what they took, I think it's still appropriate for me to identify as a psychologist. That said, that's a brand, that's a label, right? It's one thing. It's what is he actually doing?
Right.
Really, that is the key issue. But I think the court just seized upon that comment and sort of said it's, well, by your own admission, it's not off-duty conduct. And I think that was a superficial analysis and conclusion.
Absolutely. That is all the time we have. Thank you both so much.
Thank you.
We've heard today about the decision in the Jordan Peterson fight against the College of Psychologists. Are professional regulators going too far and trying to regulate the private speech of professionals? Is this a violation of the right to freedom of expression? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.